People v. Palacios.
Good morning, Your Honors. Nice, short train journey this morning. David Fitzmaurice from Appellate Advocates on behalf of Mr. Palacios. I'd like to reserve 3 minutes.
Yes.
Your Honors, when we talk about the prosecution's initial burden at a suppression hearing, what we're really talking about is that the prosecution has to tell the court what happened. So when defense counsel, like here, makes a specific allegation of a de Boer violation,
So does I think your position result in both the detective who issues the I-card and the officers who actually make the arrest, do they all have to testify? Is that your rule?
had they all testified, we would be the better for it, I think, because we would be able to analyze the nature of the initial interaction.
We all aspire to greatness, but do you need both under your rule?
No, I don't think you need both. I don't want you to mistake our position with having a problem with the fellow officer rule in general. I actually think our position
And Ramirez Portoreal suggests that you don't need both necessarily, doesn't it?
Absolutely it does. Yep. And if we think about Ramirez Portoreal and we think about, Fleming and Lott on the roof together with the binoculars.
So you agree then that circumstantial evidence can be sufficient? And so the question is there enough here?
Yeah, absolutely. And so we go back to Ramirez Portoreal and it's sufficient in that case because we don't have many unanswered questions. One sees it, they go down, they get in the same car, they go to the location.
And do you agree also that an I-card can be sufficient if the communication is clear? Probable cause I-card can be sufficient. So if one officer, creates the probable cause I-card, gives it to the other officer, and I understand you're contesting here whether there is a record of communication, but if the record shows communication, is that sufficient?
I think it would need to show to yes, but the timing actually matters here because what we're left with here is we're left with the prosecution asking that uploading an I-card to a database makes the initial de Boer interaction a level 4.
But you're not, I don't take you to be contesting, please tell me if I misunderstand, the general proposition that an I-card can be relied upon to provide probable cause.
It absolutely can. It can communicate.
So is the issue that no one communicated between the issuance of that I-card and then the defendant coming in? So are you requiring a communication for that second half?
I think we're requiring some proof of receipt, let's say, right? Because
So why isn't the proof of receipt the fact that he shows up at the precinct the next morning, right after the I-card is issued the night before?
Well, because I understand that's tempting, and that's kind of as night follows day. That's the assumption that they're asking you to make, but that doesn't actually tell us the moment that matters, which is prior to the interaction. So Your Honor's point here, and which is the prosecution's point, that just maybe at most tells us that at some stage in the interaction, they learned about the I-card, which explains why he ends up...
Do you mean the interaction between the arresting officer and the defendant, or the interaction between the officer who created the I-card and the arresting officer?
No, in that situation, I mean the interaction, the initial stop. So between the arresting officer.
Was your last comment meant to suggest that in some circumstances, the I-card could provide a post hoc justification for the arrest?
No, I don't think so. Unless the post hoc justification would need to actually explain. Basically, what I'm looking for is something in the record that tells us that the reason for the initial approach
Was the I-card.
was the level 4, was
Well,
the I-card.
what's the record of the content of the I-card?
I'd love to know.
Well, then how do you get to your argument that all you need is proof of receipt if you don't know what he received?
Well, this is my point, proof of receipt and then what they received. So for instance, we don't even know if the I-card here, to the extent it was received prior to the interaction, if it had a photo on it, if it had a description on it. Leaving aside...
Do you then need Detective Hernandez, the person who issues the I-card, to testify for that? Or can the person who received it simply say, this is what I saw on the I-card?
Okay, so had he testified to, I issued an I-card, my I-card looked like this, my I-card is in the record, then I could kind of understand how an unnamed patrol officer might be able to match the defendant to the iCard before the approach. Because we don't have that here, we're left assuming that whoever this patrol officer was knew about the iCard.
Could you use hearsay evidence wherein someone testifies other than the arresting officer that he indicated that that was in fact the basis of the arrest?
I think as long as we're steering clear of the kind of the Gonzalez problem, I think so. I mean, I think hearsay is a part of suppression hearings, but I just want to be careful that we're already relying on an inference, and we're stacking hearsay on top of the inference in an initial burden. And I do think, to answer the first question, the safest thing is obviously to just have the person say, "I initiated this encounter because I had the iCard."
But if you don't know the content of the iCard, I still think that doesn't help.
Absolutely, and you're 100% right. And the fact that we don't know if it was accessed or if it was accessed, what it would have shown, means that we cannot assume that this was a level 4
So is
at the
it,
outset.
the problem here is the insufficiency of the record to support that it was the iCard?
In this case, yes, because I mean, I know they want to talk a lot about how tempting it is, how the 24 hours later and the same precinct, but what they're actually asking for, and I want to be very specific about this, I'm not putting words in anybody's mouth, they're actually asking for a per se rule that uploading an iCard means the initial encounter is a level 4.
What if it was an hour later? What if they were on the same shift, same precinct? Are there any circumstances in which you'd have something a little closer to Ramirez Puerto Real, which is, on a roof together, would be sufficient? Or is your position that the arresting officer has to testify literally to the receipt of the iCard?
No, I think I thought about this. I thought about this preparing, and I think that I could imagine a position. I could imagine a situation where after developing probable cause and issuing the iCard, maybe someone within his unit who is involved in the investigation.
You're not arguing for, or at least you're not arguing that we need a rule, in your view, which would always require the arresting officer to testify as opposed to the officer who created the iCard.
No, I'm asking for no rules here. No.
How do we know, if we do, that the police department issues iCards only when an officer believes there's probable cause?
We don't know that. We have to assume that that's the basis. This is a kind of a,
Well, we have some
he was pretty
testimony,
frank.
don't we have some
I was about to quote it. Yeah, it was basically an arrest warrant, but like an arrest warrant, but for the NYPD only, which of course means that it hasn't gone through a magistrate. It also doesn't have the right to counsel.
Called it probable cause iCard specifically, right?
He implied that there were different types of iCards.
There are. I think there's witness iCards and probable cause iCards. Yeah, absolutely. And I think that they have different rules. But in a probable cause iCard, essentially what they're doing is, prior to iCards, this would probably go to a magistrate, and it would trigger the right to counsel under New York law.
But I thought you already told us that you're not arguing that an iCard cannot provide a basis for arrest. And I didn't hear you to be arguing that you have to go to a magistrate and that an iCard is necessarily.
No, you definitely don't. I mean, look, the fellow officer rule is a vehicle for transferring probable cause. So, there's nothing inherently inconsistent with an iCard being the modern day, telephone or bulletin or whatever, from some trooper in Pennsylvania or wherever the old cases were about, but. In those situations, we had receipt.
A different question. Let's assume here we learn that this is a level 2 violation. They go up to the person and they ask for ID. They didn't have a basis for doing that. They get the ID, they run it, and they spits out the iCard, which assume, again, hypothetically, has the information and the probable cause is established in the document the officer receives. Same subsequent facts. What's the analysis of the admissibility of the statement in that case?
So just to understand,
so level 2 violation, right? I come up to a person on the street, I ask for ID, I don't have a basis for doing that.
So it is a level 2 violation.
Right, violation. But I get the ID, I run the ID, iCard spits out, and assume again, hypothetically, iCard is in good order, has the basis for probable cause, and it identifies the defendant, has a photo. Now the same facts as we have here, brought to the station, Mirandized statement. What's the analysis of the admissibility of this statement?
I think that if we look at if Your Honor's hypothetical is tweaked slightly to they discover an arrest warrant.
No, the iCard.
I think it would still be this. I think we'd still need to analyze whether the iCard was enough of an attenuating factor. And the United States Supreme Court has said that arrest warrants don't per se attenuate in Utah v. Strife. So I think that we'd have to analyze whether the full attenuation analysis, Bradford.
How is that possible? I thought under De Boer, if the initial interaction is unlawful, the interaction that follows cannot be considered to somehow erase the illegality of the initial approach.
I'd like to think it would fail the attenuation analysis.
Well, I thought that was the question.
But I think we would perform that attenuation analysis.
That was my question.
Yeah,
You would
yeah,
perform an attenuation.
But in this
Absolutely, yes.
hypothetical, it's immediate. Where's the attenuation?
You're right. It's immediate, and I think that the attenuation analysis requires timing and intervening factors. So you're right.
I thought we didn't even know what the timing is here, right? Do we have an idea of when the actual arrest took place?
In this situation,
Yeah, our case, this case.
back to the real world.
Yeah, real
We
world.
don't even know what borough it was. Yeah, no timing, no nothing.
Right. It's very hard to do an attenuation analysis.
No, but in the hypothetical that was posed. I'm sorry. In the hypothetical that was, I just didn't understand your answer about attenuation in that hypothetical. Of course, there's an attenuation, potential attenuation argument in what happened in this case, given the timing. But I thought I just didn't understand your answer in the hypothetical.
The hypothetical is that if there was a level 2 De Boer, he shows up, he says level 2, he
You just go up to
loses.
them, you got no reason to go up to them, you ask
Yeah,
them for ID, they give you ID,
absolutely.
you go back, you run it, you find the iCard, you arrest them. I
And
thought
I
that
think
was
that
the
in that
hypothetical.
situation, it's not a case of eureka, I found an iCard, we're good. No, I think that the iCard would and the arrest, and then the fact that the statements are made immediately upon being brought to the precinct, it would all be fruit of that level 2 violation.
Okay.
So here, since we can't even conduct that analysis because we don't even know enough to know the nature of the initial interaction.
There's a potential attenuation argument
Right.
Yes.
in this case.
Yes, and we just don't know enough. So if we just think about what the Supreme Court did in Strife, the whole case is actually about.
But even in the hypothetical,
itself.
aren't we stuck with it unless there is testimony that what this iCard, or evidence, excuse me, what the content of the iCard?
Say that again?
Even in the hypothetical, aren't we stuck with the content of the iCard? I mean, you don't have this here.
You don't have this.
Isn't that, I thought
you-
really the core of your argument on this issue
that
was you don't know what's in the iCard.
We don't know if it was seen, what it was seen, how it was seen.
But even if it was seen, if you don't know what
know
it
what's in it.
contains,
Absolutely, we don't know what's in it.
you have to, okay.
That is exactly the problem here, and I don't want to suggest that I don't want to suggest that there's any legal devices that could paper over this or whatever attenuate. No, we don't get off the ground here, and it
Since
looks
your
like
red light is on, do you want to make a quick point
I
about
guess
the
I'll get-
second point?
the second point. It's a little more unusual. I think that it's similar to the iCard point insofar as the prosecution is now left, trying to defend very unusual litigation tactics at the suppression hearing.
Can I just ask you what is standard practice?
Yeah, how unusual is that?
So there must be some number of interviews that take place in a different language. What happens?
Every day. Before they were recorded, what would happen is they would put in the
I mean, in
physical
terms of
Spanish
translation.
language.
Yeah.
The Spanish language Miranda card back before now they're recorded. What happens is normally that there's a sworn translation, or normally that the witness who's there is shown the translation and can.
There's a sworn translation by whom?
I mean, I think that by anybody if there's no issue, but that I've even seen situations where there's been an issue as to translation and the court has actually employed the court reporter.
So in your
to
experience,
resolve.
At a hearing? At a suppression?
Absolutely, and it's taken judicial notice of the court reporter's termination. So nobody.
That's when the defense attorney raises an objection to a translation.
Yes, Yes, which is kind of I want to be very clear. That was done below, and this idea, if there's really this kind of hinges on one word, and that is the word aid. It's not an aid, and the reason why we know it wasn't an aid is just there's one example in the cross examination where they're fighting over a comment. You have to answer the question, right? That was what the prosecution's theory was. And again, this is during a Miranda colloquy that there's confusion and there's needed to be rewarnings. So being told you have to answer the question, not that bad. But on cross-examination, he actually holds his feet to the fire, plays the video again.
But is that an objection to the accuracy of the translation or to what the translation in fact says?
Well, so it's actually it's both, because he manages to elicit an admission. The comment was you have to answer, not you have to answer the question. But then when we go to the translation, we see that or we go to the court's opinion, the finding of fact says you have to answer the question. So this aid is actually taking the place of sworn testimony, because the testimony has disavowed that version. So there's no universe where we can keep calling this an aid, And I think that this is really easy to avoid. Courts avoid it every day. I don't think you're going to see this
So
issue.
what would be the correct way to do these hearings going forward? If you have a recorded foreign language interrogation like this, and you have to review it, what's the way it should happen at the hearing?
The way it happens in literally every other suppression hearing case I've seen, and I see them every week, you actually have a translation that's a hearing exhibit, or you have enough.
Who does that translation
testimony.
come from?
Pardon me?
Who does that translation? Can it be supplied by the people like it was in this
Oh, it
case?
absolutely can. 100%. It can even come from the detective himself. It can. He can be the one who prepared it, or he can be the one who signed
So
off
then is
on
the
it.
problem that it was not an exhibit or that it was not sworn?
I think that the fact that it wasn't an exhibit is why it. The fact that it wasn't sworn is why it's not an exhibit. So had this been an exhibit, there'd be no issue here. Like is frequently the case, we see the video, we read the exhibit, we paste it in our briefs, we litigate the Miranda issues on appeal. There's no issue. There's no, transcript appearing for the first time in the prosecution's appendix.
So could they have admitted this transcript
Pardon me?
as a court exhibit? Could they have admitted it here?
So I don't think they could have admitted it, because I don't think it was it was unknown.
It's a hearing, right? It's not a trial.
No, but it is. Nobody has sworn to its accuracy, So I don't think we know enough to. I think he was dead right, and he's not. This isn't pulling a fast one at the end. He's alerting. He's jumping up and down, saying this is a problem, and during, after, post-hearing briefs,
If
reconsideration motions.
the officer here who did the transcribing, if
We
questions,
don't know who did the transcript.
if he had,
Okay.
if he had been the one who transcribed it, and he is the interviewer, if he testified under oath verbatim as to what was taking place in the during the questioning, would that suffice?
Yep, that would absolutely suffice, because then it would really shift over to defense counsel then to the burden would shift, and
Because
it
he
up
would
to
be
him.
under oath at
Yeah, and he could cross-examine properly, and he could, he'd have all the facts in front of him. But here, that's not what's happening. The only sentence he said is, "I read him his Miranda rights."
Leaving the substance out of it, I just want to make sure that I'm getting this. The problem with the court relying upon the translation they were given is, if I understand you correctly, simply the lack of appropriate certification.
Yeah.
So
Yeah. And the fact then, therefore, that it's not in the record, so that therefore, when we read its findings of fact, it's now gone outside
Let me
of the
ask
hearing
you
record.
this. If you look at the video, he does appear to be reading off a card. If they didn't admit that card, and he simply said, that card is, in this case, Spanish, the Spanish language version of Miranda rights, I read that. If he said that, do you agree at that point then it shifts to the defendant to challenge?
Certainly closer, yeah. If he said, I didn't paraphrase it, I didn't, I read verbatim the card, seen cases where the card itself is put in, yeah,
Or
absolutely.
even without the card being put
Even
in,
without
the
the card
officer
put in, at
saying,
least
and that
have-
card was a correct translation of the Miranda rights in Spanish. I'm a Spanish speaker. I read them to him.
I think we're now starting to look like what these Huntley hearings normally look like. Absolutely.
And
that's
that
why
could
this
be
is,
also one question to the officer. Have you reviewed the transcript and is it fair and accurate translation?
I think then I'm not making this argument to this court. Absolutely. Whatever about defense counsel may be still trying to push the burdens below and stress test things, I'm not including it as a point two in this brief. I can tell you that much. If there are no further questions, Your Honor, I will rest on my briefs.
Thank you.
Good morning, Your Honors. William Brannigan for the Office of District Attorney Katz. May it please the court. May it please the court. Your Honor, as to the first issue, because the detective's probable cause was communicated by this iCard, and because the defendant was arrested the next day and brought to the officer's
What's the
precinct-
content of the iCard? Was that anywhere in the record?
No, Your Honor. He only testified that that this iCard gave probable cause as a probable cause archive for the
How
for
can
arrest
that
of
be
this.
enough? How can that be enough?
Because that iCard gave probable cause to arrest this defendant, and the court
But I'm
could
saying,
make,
how would a judge know that if they don't have the iCard or at least an explanation of what the officer put in the iCard?
Your Honor, because the court can infer that by the fact that the defendant was arrested and brought to this detective the following day. And so the particulars of the iCard,
The court can infer that there's probable cause in the iCard from the fact that the defendant was arrested the following day?
no, Your Honor, the court can infer that because the detective testified that this probable cause was, that this iCard was based on probable cause after the witness had identified.
What
this
if it
defendant.
just says arrest Mr. Palacios and that's all it said? Is that enough?
Your Honor, it would be enough based on this card's based on the court's fellow officer rule. So ordinarily, if officers are told that they can arrest a particular person and they arrest that person, the burden would then shift, of course, to the defense to make allegations.
Yeah, but in the fellow
that the-
officer rule, the way I
Right.
understand it, Mr. Brannigan, there has to be some communication between officers. Are you saying that the iCard is a substitution for that communication that stands as another officer? Is that your argument?
Well, first, Your Honor, I just want to back up for a second. In this case, we had an officer testifying to what the probable cause was, and that the probable cause was communicated. It's not a situation where a person's being told where we have.
communicated
other
how,
than
though?
through the iCard? You just said there's testimony that probable cause was communicated. Is there testimony that it was communicated other than through the creation of the iCard?
No, Your Honor. The testimony here is that the probable cause was communicated through this iCard.
So the iCard is the fellow officer.
Well, the fellow officer is the fellow officer rule is the communication. This is the communication.
I mean, normally you would bring in the officer who made the stop and you would talk about that as being the fellow officer who was relying on the information. I'm saying there is no other officer here. There's an iCard. And is it your position that the iCard is taking the place of that officer?
No, Your Honor. I'm saying that this court can infer that communication, or rather that there was that the recipient received that communication based on Detective Hernandez's testimony that this iCard communicated the probable cause for arrest.
I thought
the
Mr.
entire
Palacios
police
was wanted
department.
for something else as well, no?
I'm sorry, could you repeat the question? Your Honor?
Is there something in the record indicating that Mr. Palacios was wanted for some other reason as well?
Yes, Your Honor. During the interview, Detective Tavares, I think, joined the interview because he had suspected the defendant in a separate robbery.
So
And
then,
did that suspicion rise to probable cause to arrest for that potential offense?
That's not in the record, Your Honor. And again, we're not. I'm not arguing that there isn't some other possibility out there that they were looking at him for that. But the evidence before the court allowed this inference,
Counsel, I'm sorry. How do you exclude my hypothetical about a DeMoore violation?
First, Your Honor, I'd go back to Ramirez-Portorial, and I don't think that there was this type of analysis that could have been done, even in that situation where you have a close in time and proximity
But you have overnight
arrest.
here, right? You have no testimony from the person that arrested the defendant. How do we know the circumstances of that and why we wouldn't need to do an attenuation analysis?
Well, first, Your Honor, the court can make the inference, and the defendant's allegations
Well,
here.
it seems that you're asking the court to make that inference on the fact that an I-card, which isn't in the record but has probable cause in it according to testimony, was somehow viewed by that officer the day after at some point. We don't even know the timing. And then that was the basis for the stop. But why?
Well, why? Because the fact that that officer arrests the defendant, brings him back to
Yeah,
the.
but we don't know how he arrested him. What if he went into his house and arrested him and brought him into court? Like, wouldn't that be information that the hearing court should know and evaluate?
Well, the defendant's allegations here were that he was arrested on the street, and he didn't make any allegations either that he was in a house, that he was otherwise mistreated. So those allegations are
The
consistent.
inference that you're arguing for can't be dependent on what the defendant says to challenge the arrest, right? I understand your argument to be that there's close temporal, maybe physical proximity, and therefore you can assume, courts, that the reason why he was arrested was because of the I-card.
That's correct, Your Honor. That
And-
is
and-
our argument.
Is your position that some temporal and physical proximity is required, or that any I-card, any borough, any time is sufficient?
No, I'm saying under these facts where it's the next
But
day.
what's the rule that you're asking us for?
Your Honor, I'm not asking for a per se rule. I'm asking that this court.
Well, you are
confer-
asking for part of a rule, because in response to me, you said the I-card is enough. You don't need to know its contents.
Your Honor, well, that is true. As long as the I-card
So
is
that's your
providing-
rule. You don't need to have the contents. You just need testimony, whether it's the arresting officer who says, I saw an I-card, or it's the officer who filled out, or however you call it, initiated, distributed the I-card. Correct?
Your Honor, you need testimony that the I-card provided probable cause for a certain.
Well, how do you do that without knowing the content?
Because what we don't, it would be better if we had the I-card. We don't have that. What we do have is testimony that the I-card provided probable cause for the arrest of Mr.
No, you have
Palacios.
testimony, the detective says, based on what an alleged victim said to me, I believe that, and identified, of course, Mr. Palacios, I believe that I had probable cause to arrest, for him to be arrested. That's what you have. You don't have, and that's what I put in the I-card, or I put something in the I-card.
No, Your Honor, he did say that this was a probable cause I-card and that this I-card provided probable cause to the entire.
But again, what does that mean? That it just says arrest Mr. Palacios?
I don't know. I don't know what was written in the I-card.
But isn't
I
that,
know-
that's what I'm saying, isn't that a challenge to your position?
Your Honor, I don't think it's a challenge because there was probable cause to arrest him, and we know what the probable
How do
cause
we
is based
know
on.
here that it wasn't something besides the I-card that caused the arresting officer to arrest without your inference?
Because the strongest inference from the facts here, which the hearing court drew, was that this I-card was the basis.
But
It's
you
possible-
agree it's based on an inference. There's no let me ask you, is there anywhere in the record where it clearly says that the basis of the arrest was in fact the I-card without the inference?
Well, no, Your Honor, we do not have the arresting officer. The court could draw that inference, though, based on these circumstances.
Suppose we kept all the facts the same, but the arrest takes place 3 days later. Does that affect anything?
It is a factor. It's a worse case than this
Why?
case. Because I
I mean, the
think
probable cause hasn't diminished,
because
right?
Your Honor, it's the same thing. The closer you get in time and space, the more likely it is that this was in fact that this provided the probable cause. The further you go out, the more.
Was it close in space? Was he arrested nearby where the probable cause crime occurred?
There's no record of that, Your Honor.
So all you have in this case is time. It was a short time later. Because
Well,
you
I
can't
also-
even, or we're certainly not allowed to infer that it happened close to where the other crime happened, are we?
On I wouldn't guess as to the location, but he was brought to the precinct of the issuing officer, and the issuing officer
The
immediately spoke to
location
him.
is simply the precinct, not anything more specific than that.
Correct.
And I take it you agree that then that temporal and physical proximity matter in determining whether the fellow officer card can be invoked, rule can be invoked with an I card.
Yes, Your Honor.
Yeah, but in this situation, a police officer could have just made an arrest and then ran it and said, "Oh, look, lucky me, I've got an I card now, so that can justify this arrest." How do we know that didn't happen here?
Your Honor, I can't exclude that completely, but that's speculation, and the court could still infer. The court could still infer from these circumstances. And again,
It's not clear what the line here is between speculation and inference.
The line is that the inference has some support in the record. Here, the court's finding that this arrest was based on the I card is based on that issuance, based on the actual probable cause, and based on the immediate return to the precinct and the detective's interview. So the court here had all of this evidence to
So
draw that
again, so that
inference.
I'm clear, even without us having the I card to review, the mere fact that someone says it was issued, we have to presume that it did suffice to establish probable cause just because someone said they created it.
Well, no, Your Honor, because here we actually have the testimony that the witness had identified the defendant as the perpetrator in the arson. So we actually have the probable cause.
Is the inference rebuttable? If
yes,
the
Your Honor.
defendant comes in and says, you know, that cop who arrested me was just giving me a look. He just wanted to arrest me. It had nothing to do with the I card at all.
Yes, Your Honor.
Can they do that?
Yes, Your Honor. And again, something similar happened in one of the cases cited by the defense. In Gonzalez, there was a testimony.
And without the arresting officer there, I don't mean to conflate it too much with the actual facts of this case, but without the arresting officer there, how do you greet that rebuttal? How do you, as a district attorney? Well, I don't have the arresting officer here, so all I can tell you is you should rely on the fact that an I card was issued. Is that a good argument to make to a court?
Your Honor, that would be not a good argument. If there was something more, but again, you'd have to imagine what they would come in and actually say. There was something bad in this initial stop. Then I think our argument would have to change.
Can I ask, in your experience, is this unusual not to do one of the following? Bring in an I card or a depiction of the I card that was issued, or testimony as to the contents of the I card and how it's distributed?
Your Honor, I think again, I actually don't know how often they're put into evidence in our cases. But in different cases, you'll find different evidence.
Can I ask you about the Miranda question for a minute? So it seems to me that what we have here, let's assume I don't speak Spanish and I want to evaluate the transcript to test the Miranda claim that we have. So the transcript, I think, appears only in the appendix to this court for the first time. Is that right?
That's correct.
Okay. That seems highly unusual to me. Is that standard practice?
No, Your Honor. I think so as far as there's a few things here. First of all, the court relied on this as its aid and maintained.
But I'm focused on the reviewability question. It sounds to me like there was not a translation that was provided to the second department. Maybe none was necessary. Maybe everyone spoke Spanish. I don't know. But the notion that something is not part of the record, and we're being asked to evaluate it for its substance, which I think we are, and then it just is presented in an appendix to this court. I'm not sure I can think of another example where I've seen that.
Your Honor, my first response, my first argument is that this is part of the record, and that the fact that
Well, wait a minute. When you say it's part of the record, it was not, as I understand it, in the record as it left the trial court, and it's only before us now, as I understand it, and I thought you just said because you provided it to us in an appendix.
That's correct, Your Honor, but that came out of the court file.
Okay, so it was not accepted as an exhibit, but it was in the court file?
It was in the court file, yes.
Okay, and so you're asking us to take notice of it just as something that's in the court file?
Yes, Your Honor, but I'm actually asking you to take notice of this because it was something that was relied on the court in making its decision. And I did cite, I think, appellate division law and
But
court
defense
rules.
counsel did object to putting it in as an exhibit, I thought. Is that not right?
He did, and the court used it as an aid, and the court relied on it.
And did not take it in as an exhibit?
That's correct, Your Honor.
In the
Did
face of
counsel
that
object to the use of it even as an aid?
I don't know the exact objection, but he objected that he couldn't put it in as an exhibit and that it was not certified.
Is it typical practice not to have either, I think you heard a couple of questions when your adversary was up, for example, certification or a question as to whether or not the translation was accurate, something along those lines to establish its accuracy. Is that typical to proceed that way?
Your Honor, I don't know how often it is done this way. I can say there were other ways that could have been done here. The detective could have just testified to what he had said without going through any of this. That would have precluded this issue. But the fact is here, the exhibit itself, the tape of the interview, that was the evidence here. That was given to the defense ahead of time. They produced their own translation. Each side came in with its own translation. The defense could have asked the court to look at their translation as well. So the process here, even though this was unusual,
They
the
didn't
process
do
here was
that,
fair.
counsel? The defense didn't try to hand up its, I don't know, competing or maybe not competing translation?
No, Your Honor. No, Your Honor. And again, when you look at
So your view is that objecting to taking it as an exhibit was not sufficient. Why is that?
well, Your Honor, it's not sufficient as far as if the idea is that by objecting they can somehow make an absent record, no. If they want to say that there was a defect in this translation, they should have explained that this is why it was defective and couldn't support this, but not for the
Isn't
point.
your burden to establish that the translation is an accurate one before they have to do anything?
No, Your Honor, we provided the translation, we provided the tape to the defense. They had the ability to view it during the
You can
hearing
provide a
itself.
document without saying who worked on it, what is their language capability, and then the burden shifts to them to somehow challenge that?
I don't, Your Honor, I don't like.
Or it's acceptable, I should say this.
I-
It's acceptable given that representation?
I don't like the analogy of this being that the evidence we put in was the tape. We
Yes,
gave
but the
that tape-
video, no one can rely on it because it's in another language. You obviously need it translated, correct?
Yes, most of the people.
I mean, even if the judge knew Spanish, the judge can't be a witness in the case.
Your Honor,
Say, I understand what was said, and here's my conclusion based on what I understand what was said.
Your Honor, there's nothing that would prevent the judge from doing that. If the judge spoke Spanish,
There's nothing that prevents the judge from being a witness in the case?
he's not being a witness. I don't think that analogy is proper. The evidence here is the video itself.
So are you saying the judge could have watched the video of the interview and said, I got it. I watched it. I understood it. I know what was said. And here's my ruling now on the suppression motion.
The judge could have said, assuming, and again, Your Honor, the real issue here is whether there's a fair process. So here where...
How do you have a fair process for appellate review?
I'm really trying to understand how that's a fair
And how could counsel, what would counsel do? Judge, I need you to take the stand and tell us your linguistic capacity to be able to actually understand this video?
Well, the defense attorney could object to that, but here, so for instance, in this,
And should that objection have been recognized? Should the
well,
judge
it
have
didn't.
said,
Well,
you know,
well,
you're
first of
right,
all,
I really shouldn't rely on my
Your
own
Honor,
understanding?
it did not happen here. My point is that the video is evidence that it was given to the defense, that both sides had translations.
All I'm saying
that
is
they
that
were-
the video in and of itself is not, I agree, there is a video. I'm not going to say otherwise that it doesn't matter, but no use could be made of that for purposes of the suppression hearing without an accurate translation. You agree?
Yes, it needs to be translated, but it is still. the
Wouldn't it
evidence.
be good if we were all sort of working under the same set of facts? If there is one translation that's certified and admitted, or even if you want to, we could go take this further and have competing translations. But if you could just get one thing in where everybody agrees this is the official translation of what was said, and then we make rulings based on an agreed set of facts, isn't that better than just sort of this, I don't know, loosey-goosey thing where you hand up a translation and you say, okay, judge, use this as an aid. And the judge says, all right, I'll use it as an aid. But we don't even know how they're using it or what they're using it for.
Yes, Your Honor, but again, there is a video that the court can watch and follow along with, and you could watch the interaction.
But if you don't speak Spanish,
What are you
how-
following along with?
You're following along with the translation aid, and if the defense had an
Oh,
issue
wait a
with
second.
something,
I really find that hard to follow. If I don't speak Spanish, then what use is watching the video, which I understand is in Spanish?
Your Honor, my argument is that the video is evidence that this translation is an aid in understanding that. And other courts have found that translations are, or transcriptions are aids in following an admitted videotape. So here, that is what's admitted.
Yes, but you have the burden of establishing that the translation is accurate. Otherwise, what's the point of an inaccurate translation?
But Your Honor, I don't think if you're suggesting that as a rule, I don't think that is a necessary rule. I think, Your Honor, as long as as long as
It's
the court,
unnecessary to get it right?
it is, Your Honor. But once the people came in with this, the defendant, instead of simply saying, "I'm not
No,
going,"
are
I'm going to,
you really saying that you could bring in a transcript, doesn't have to be certified, you don't have to attest to its accuracy, and somehow the burden shifts to the defendant? It's not your responsibility, it's not your burden? Is that what you're saying?
I am saying, Your Honor, if that is all that we did, that would be a problem. That would be a problem for the process of the hearing. But here, where the tape was provided ahead of time and they had their own translation, then it is not a problem.
And then the court inquired of defendant about using that translation, and the defendant said, I object. And the court said, all right, I'll just use it as an interpretive aid then. And I don't understand what else it could have been used as other than that. So, I mean, how is this not that unacceptable scenario? The court took it, as you said, it's in the court's file. It became part of the record. It was used in some fashion, and it wasn't agreed to.
Your Honor, because we had a hearing here, everyone was able to follow the hearing because both sides had produced translations. The defendant was Spanish speaking. They were able to cross-examine the witness. And even in part, if you read the testimony, the defense attorney is using the Spanish language to cross-examine
Well,
him.
then why do you
So-
need the video at all? Why do you need the video at all?
Well, the
I've
videos.
got my translation, you've got your translation, Judge.
No, Your
Figure it
Honor.
out.
But without the video, then the aids don't even make sense. You have to watch the interaction between the defendant and the detective on the video. And again,
The interaction tells you whether or not Tavares said you have to answer or you have to answer that question.
No, Your Honor. The aids do that. The translation aids do that.
And what if you have, how does watching the video in any way aid, excuse me, I don't want to use that word. How does using the video in any way resolve that question?
Well,
What the detective said?
Again, you do need the aid and you do need the testimony. And again, here.
Didn't the
if
testimony demonstrate that the aid was wrong? Had a mistranslation?
Your Honor, there was, we're pointing to one word, or possibly.
Sometimes a word can be
The
important.
detective is being asked, about whether he said, did you, you have to answer the question. The defense attorney is saying to him, no, it's, you have to answer I'm sorry, you have to answer versus you have to answer the question. So there was a dispute between the detective and the defense attorney, or rather that was a subject of cross-examination. I don't think it was a material a difference, and the defense counsel was able to cross-examine him on that.
Well, then why didn't the court, based on the testimony, rely on the testimony rather than the aid?
Because the testimony, what we're talking about here, and there was testimony about the Miranda, but it wasn't sufficient. The argument here, and I think it was below, is that what the detective did not do in this case was to go through each warning. So that was not covered. That was not covered by his testimony. And the detective, of course, did testify that he was a fluent Spanish speaker.
Thank you.
Thank you, Your Honors.
Counsel, on the Miranda point over here, are you objecting to the accuracy or to the procedure, to the lack of some attestation to its accuracy?
I think that they're two sides of the same coin, because I think that had the accuracy been established, there'd be no reason to.
But
to
are you
object to this coming in.
here objecting to the accuracy? Are you saying the people argued just now that you didn't object to the accuracy in the moment, and I think that one could read the record that way. Are you objecting now to the accuracy?
No, there was an objection below to the accuracy.
Back and forth about did he instruct him to answer the question?
Well, so that was the testimony he elicited, but if you read his papers afterwards, he objects to it being entered into the record. He objects to it being used in any capacity, even as an aid.
Yes, I understand.
So he maintained accuracy and foundation objections to this, which is why we have never seen it until now, which is quite shocking. Yes, it's from the court file. I'll just note that.
But you saw it at the hearing, did you not? They provided a copy to you at the hearing.
So defense counsel was. You're to be clear. Yes, a defense counsel was provided. I will say that.
And the defense had their own translation.
Yes,
And did the defense ever say, "Hey, judge, don't use theirs. Can you use ours?"
No, but I think that don't use theirs means there's a zero in the column, and the column is that they need to prove the validity of Miranda beyond a reasonable doubt. So I think.
But is your objection that the court relied on it as part of the evidence? And really, is that really your objection?
The objection is that.
Because sometimes like a Spanish-speaking officer can testify without a transcript, correct? And just say, this is the process I went through, I read these rights, I'm a Spanish speaker, and just give testimony without a transcription.
You're right, but there was no testimony here, and that's actually.
No, I know, but I'm just saying in general, that could happen, right?
It does, and the suppression hearing is normally a lot longer as a result, and that's one thing that we agree on. They didn't do that way here, where maybe you would elicit direct testimony about the Miranda and the exchange, and that way you don't need the video, because the video is immaterial. You have sworn testimony that you could cross from the person involved who speaks both languages.
Counsel,
But here
just
they've
so-
outsourced it to the video.
Just so I'm clear, to go back to Judge Halligan's question, is there anywhere in the argument below where the defense came in and said, you translated this word as X into English, but it means Y?
There was a few points where when he invoked his right to silence, and whether he said no, estoy bien, or just no, and so there were a handful, but there was never a time where
Is
you're
that
right. he said it to the
audibility,
court.
or is that you translated it different?
Pardon me?
Is it an audibility issue? He said two words, or is it these two words mean something else, and you translated it inaccurately?
He never said to the judge specifically, this is wrong, this is wrong, this is wrong, and this is wrong.
Or even one. One, this is wrong.
Well-
One, this word is not an accurate translation. One.
Well, he elicited testimony. So what he did was he got the officer to walk back that version and to provide
I
testimony
read that
about it.
testimony. I think it can also be read as the nuance of what was being said, the tone. What did I mean by that? Instead of this word in the transcript isn't there, or this word in the transcript, this translation is wrong.
You're right. It could be nuanced. I mean, Spanish language is subject to a lot of nuances, a lot of different
No,
dialects.
no, no. But counsel,
But
there's no dispute here that the words that were translated were no, which is the same in English and Spanish as I understand it. And then sometimes he says estoy bien after he says no, right? And really what they were debating is, well, what does that mean?
what it means within the context of someone who is admittedly confused and needs
Agree,
to
but
be
it's not a
re-Mirandized.
question of what do the words say. It's a question of how did he mean them. So it's not those two words should be translated differently. You can argue those two words translated, but that's meant something else. And I think that to me seems like what that back and forth is about.
But the bigger problem here is that the record does not have the translation in the record.
That's the process point.
Yeah.
So that's a process, which is why I think and because of these issues is why he objected. Had there been no issues with the translation, he wouldn't have taken the unprecedented step of objecting. Note that the co-defendants counsel didn't object to the issue. So he did have misgivings. He had his own version. He cross-examined using his own version. He managed to get him to walk back some of the inaccuracies, and then he objects, and then it's not in the court file until now. It's not in the court file when judgment is perfected and when we're assigned to the case. It's in the court file. I accept that the prosecutor got it from the court file. But I can tell
Well,
you
even if it is
wasn't
in the
there
court file,
recently.
what does that mean? I speak
Well, so
Spanish and I read Spanish. I'm
well, so
going
it
to
just-
read it and inform my colleagues who may not know Spanish. Oh, this is what this says?
Well, it just tells us that,
I'm going to look at the video and the translation and say, yeah, it looks accurate or it doesn't.
but, the video is in the court file because it was a hearing exhibit.
No, I
It's in
understand
the
that.
video. So the translation is not in the court file. It's not a hearing exhibit. That's why there's all this confusion and it, all this back and forth.
No, but there doesn't seem to be a dispute that it wasn't admitted. And there doesn't seem to be a dispute that the judge used it as an aid. I mean, counsel just said that.
Yeah, but now
So the fact that it's in the record, what would we make? Let me ask you this. What would we do with the fact that it would have been in the record in some way?
it wasn't in the record though.
Yes, right. It's not in the record. So I'm not, but my point is I don't understand what difference that happens to make, other than, yes, we shouldn't look at it even if they've presented it now. But all I'm saying is if it was in the record and you have no testimony, no other evidence about whether or not it's an accurate translation, what would we make of it other than deal with that issue? And you don't need the document for that because they, of course, did not put in any evidence about the accuracy.
Yeah,
of
so
it.
what I'm saying is that they've outsourced all of this to the video. They've elicited no testimony on direct, one word, I read a Miranda. Defense counsel has chipped away as pursuant to his burden. He's chipped away and explained, why there's some confusion and he didn't understand certain things and he invoked his right to silence, but then he kept talking. So they've outsourced the answer to all these questions to the video, but then the video is not, but then the video is not translated. And so it's really just it's an accuracy problem. It's a process problem. Judge Canataro, your question about isn't it better to just have an official version? Yes, and that's what we see all day, and that's why no one has been able to point to a single example of this happening before. And I don't.
And yes, that's another point, because if it's not an official or a certified translation, again, what is an appellate court going to do? You can't read it and then decide for yourself, right?
I don't know. Yes, I don't know,
okay.
because if you're to just think about what the appellate division did, it said it affirmed the denial of suppression based on the evidence in the record. It didn't have the
But is it
translation.
your position that there's certified transcripts of foreign language statements at Huntley hearings, that there are certified versions? That's your experience?
Yeah, all the
And
time.
conducted by whom? The people have?
Literally, whoever made this one could have just attested to it.
Okay, so it's different than having an official.
No, yeah.
Yes, okay, got it.
Sometimes I have seen cases where actually they use maybe a court
At
interpreter.
trial, right, I could
And at
see
trial
that,
when there's
yes.
a jury, I get that, absolutely. So I
Your position is if they had done that, if let's say, the person who had actually composed this translation had taken the stand, that then the burden shifts to the defendant. Is
Yeah,
that
I
what
think
you're saying?
so.
At that point, to then challenge either perhaps they got it wrong, but they're qualified to do it, or despite what they say are their qualifications, they are not actually able to accurately translate.
Absolutely. And when we actually read the exhibit that was part of the appendix, and whoever typed it said unintelligible, but then someone else came along and hand wrote what they thought it meant. So we're just this is not
Can I ask you on the
consistent with the
first? Yeah,
evidentiary.
can I ask you on the first question, since your red light is on, your position on his response to my question? If the iCard had said arrest Mr. Palacios, would that have been enough? If either Enriquez has testified to that, or there's other evidence that's admitted that that is the actual content, and that's the only content, would that have been enough?
No, because that wouldn't tell us how he knew who Mr. Palacios was without doing an initial stop. So that wouldn't be enough to tell us that the initial stop necessarily was a level 4. Maybe if it was arrest Mr. Palacios, here's what he looks like, photo, description, then maybe we can say, okay, well, maybe someone walking around the street, if they happen to see somebody, maybe, although I'm not even sure that's tenable because there's an untold number of iCards in place. So the record doesn't tell us what was on the iCard, whether it was accessed, how it was accessed. And I want to be very clear, they are asking for a per se rule here. When they come along and they say that this was a level 4, and to quote, the circumstances of the underlying encounter were not relevant, such that we don't even know who the arresting officer was, that's asking for a per se rule that the assumption applies to everybody in the New York City Police Department, all because they wouldn't just produce the witness at the hearing. So they're asking this court to bend over backwards and write a NYPD per se iCard rule simply because it's objectively out of step with the fellow officer rules, actual communication, or Ramirez Puerto Real know everything except maybe the final communication. So they are asking for per se rule, and if you look at what the first department and the second department, who are the only 2 departments who deal with this, they're using words like issuing an iCard mandates the inference. That's a per se rule, and that's why we're here to ask this court to intervene. And I don't really know how to square this with De Boer. I don't know how someone can establish a De Boer violation in an iCard case. Because if someone comes along, like we have here, and says, hey, this was a De Boer violation, the response is, too bad, there's an iCard, we don't even need to tell you what the level was or even the name of the officer. And so actually we have a De Boer 1, 2, and 3 not applying because we just assume that it's a De Boer level 4 because someone uploaded an iCard to the iCard database. And I think that, the last thing I'll say is, it's interesting to hear about the time and space, proximity issue, because there was another investigation, and it was about an offence that was from a month earlier, and because they didn't introduce the iCard here, we don't know if the iCard corresponded to that investigation too, which I submit that if it did, it would really take the wind out of their sails, because this idea that 24 hours later he was picked up.
But the testimony is that the iCard is issued based on the statements of an alleged victim to Enriquez and the victim's identification of the defendant.
Yes, Your Honor, but what I'm saying is when he's brought to the precinct, he's interrogated by Tavares about an offence from a month earlier.
No, I
don't
understand that, but
know.
I'm just saying with respect to the iCard, I don't see how this
I know, but
other potential investigation has anything to do with the iCard.
Well, because it would show that if there was actually an iCard in place for the month before this.
Oh, I see what you're
this
saying, that
idea
maybe there was another iCard out there.
And this is why, or maybe it's the same iCard that probably has both things on it. And this is why we go back to the thing I said at the very beginning, where this is an initial burden. You just have to tell us what happened and let defense counsel then litigate the issue.
If the arresting officer had either been the only one to testify or also testified and said, I saw the iCard and that's why I arrested him, is that enough if you do not know the content of the iCard?
That's a good question, because at least
Thank you.
at least we have at least we have some target then for, well, there's something in the record that confirms that some human is saying I initiated a level 4, not some legal abstraction, a human saying it. So maybe you'd still have a problem, and maybe that problem.
Because aren't you at that point communicating Enriquez's
Yeah, exactly.
I have probable cause, I'm telling you to arrest him.
Exactly, and so then the fellow officer rule has never demanded parity of information with the receiving officer. The receiving officers never needed to know the ins and outs of the probable cause. So yeah, I think that in that situation, we'd be
Well, we do need to know what the communication is.
the communication, but not the ingredients
Yes,
of probable cause. And that's the whole point of this is why I'm saying my position is consistent with the fellow officer rule. It involves no per se requests, and it's just asking this court, to uphold De Boer, Gonzalez, fellow officer rule. And I think that when we look around nationwide, this is not the time for this court to roll back decades of very robust street encounter jurisprudence and to allow a fiction of an NYPD only, arrest warrant, except it's not an arrest warrant, to carve gaping holes into all of these cases.
Thank
There are
you.
no further questions, Your Honors. Rest of my briefs.